the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it.
If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep. What's up, YouTube family? Welcome back to the channel. I'm your host, Jay. And man, y'all know we got to talk about this Young Thug YSL Rico trial. Man, today it went left in the courtroom, and trust me, this one's going to leave you speechless. Now today, the judge finally had enough of the state and the prosecutor, and man, has the state actually been misrepresenting the evidence, misrepresenting the fact? And ask yourself this even deeper, is the judge just not catching on? That the state has purposely been putting the defense at a disadvantage when it comes to this trial all along? If you haven't subscribed, definitely subscribe to the channel. Tap that notification bell so you'll get that drop whenever we drop. And hit that like button. It definitely helps the channel continue to grow. Y'all know the vibes. Grab a seat. Man, we finna dig deep.
All right, Mr. Weinstein, you wanted to address something?
Yeah, just briefly, Your Honor, and I'm not sure when the state plans on using this, but on the 27th of September, so what, 3 days ago, we got a Dropbox link with additional crime scene photos from a 2019 case, a 2014 case, and a 2015 case. These hadn't previously been provided.
Of what?
Well, I think you'd have to ask maybe Mr. Atkins or the state. One of them relates to, I just have APD case numbers. I think they could give you more detail.
Okay.
My main point being these should have been provided in December of 22 at the latest. So I don't know why we're just receiving these now. And it seems to be my role in the case. I'm here to, once again, complain about late discovery, Your Honor.
Ms. Love?
Your Honor, I'd ask the court, since that is not something that will be broached this week at all, that the court allow us to address the matter when I have those files in front of me that Mr. Weinstein.
How about you get those files at lunch? Seems to me like we're going to have a lot to talk about over lunch.
We can do that, Your Honor. And also, I will say that those are, to the extent that, of course, I will look back and make sure that they were not previously provided, but to the extent that they were not, the crime scene information that we have turned over is a direct result of matters and witnesses that we have added back because of the objections that have been made. And the CAD reports, I believe, have already been admitted as evidence. So there is nothing about the photographs that would create any delay or prejudice or anything of that matter, but I'll address it at lunch.
What were the dates?
These are cases from, according to what Mr. Atkins sent, 2019, 2014, and 2015, Your Honor. And Mr. Atkins, in an email to me on that same date, the 27th, indicated to me that these had not previously been provided to us. So we can discuss it at lunch as the court wishes, Your Honor.
Okay. Ms. Love, in your Sunday 6 p.m. email, you said that you were going to forward later in the evening to counsel and the court the portions of Mr. Zachary's interview that you were seeking reconsideration of based or because of, I guess, the way he testified. I'm not in receipt of that forward. Did you ever forward what the actual portions are?
Your Honor, I think, no, I forwarded the transcript, the corrected transcript that I was seeking.
But you didn't forward the portions that you had that either I had ruled out or you had agreed would be out?
I did not forward those. There were.
And yeah, that's what you expected everybody to argue this morning without even knowing what those were. Could you please forward those at your earliest convenience so that we will know by lunchtime what it is that we're talking about?
Absolutely.
So let's dig. How many times have we heard this story? The state is withholding evidence. The state's not turning over information. The state keeps coming up with excuses why they can't submit the information or the evidence that they plan on using. They can't submit the witness list. The judge orders them to do it. They got a storyline or the reason why, an excuse, an alibi as to why it can't get done. But you're the prosecutor. Now, if this was the defense, this would be a whole different scenario and story. But with it being the state, how much of this is the judge going to take? Let's dig.
All right, so is Mr. Sprinkle out there ready?
He said that he needed 10 minutes from the time that I reached him. So
Tell him, text him now and tell him he needs to get over here right now.
he is, Your Honor. He is coming. He
Text
literally.
him anyway and say the 10 minutes, he can't have any more time. He needs to stop what he's doing right now and come on. Because we have the jury waiting.
Yes, Your Honor.
The Bonneville was parked there from 6:41 p.m. to 7:17 p.m.
Okay.
At 7:17 p.m. it pulled off simultaneously with another vehicle, with whom one of the occupants of the Bonneville.
Who was it that you believed you saw the other vehicle that pulled off simultaneously?
I'm going to object. Same objection as previously.
What did you say? Same objection as previous? Is that what you said?
Yes, in regards to his opinion of who he saw and best evidence also.
Your Honor, my question is, I hadn't finished it, but my question was, with respect to the vehicle that he saw driving off simultaneously, what informed the next step in his investigation in terms of what?
You may ask that question.
Specifically, did you find a number or did you locate a number you believe to be associated with the demise McMullen?
I did.
What number was that?
Hold on, I'll have to refresh my memory on that. That number was 470.
Your Honor, I'm actually going to object to that testimony. Any information that he received from hearsay would be inadmissible. I object to it.
From what would be?
Hearsay.
Your Honor,
Sustained.
I'm actually asking not whether it was. I asked him whether or not he found a number that he believed to be associated with this person.
That will be hearsay, Your Honor.
It's not talking about what anyone else said. He hasn't even gotten into other things that he did to
To the extent
look
that he,
into that number.
to the extent that he received that information from someone else, and to the extent that it's being offered for the truth of the matter asserted, specifically that that number belongs to a certain person, that would be hearsay.
It is being,
Sustained.
Your Honor. All right.
Wait a minute. So we're going to start the week off withholding evidence, ignoring the judge, and your witness is late? This what we doing? See how productive this is when it's coming from the state? Let's dig.
So I'm unclear where you're trying to go with this, which is why I'm not sure if those are valid objections or not.
Your Honor, as it relates to the other incidents that DDA Sprinkle obtained information relevant to this investigation, there were several, and I think that the jury has heard evidence of many of them. And the information that he got from those other case files and how he used it in this particular case, we believe is very relevant.
What do you expect his answer to be? What other case files? The alleged retaliatory back and forth that the state's theory has led to this? Or what? I mean, I don't know.
So, no, and the state's theory is not that the back and forth, retaliatory back and forth.
Just answer what it is that you think that is going to be the other incidents.
Your Honor, the Dexter Montgomery incident, the Adele Drive incident, incidents that involve Mr. Copeland.
All right, and what are the objections?
All right. So the objection is relevance. The objection is that it explains his course of conduct, which is not necessary and not relevant. I think the predecessor court heard at length the information about Dexter Montgomery. Several witnesses were called, detectives, investigators, witnesses from the prison system. And so the jury has heard that evidence before. They have heard the evidence about the Adele Drive shooting, both from officers who have come before the court and testified about it, as well as individuals who were there at the location. They have heard from Mr. Copeland for a long time, and both videos of him, detectives testifying about him previously, officers testifying about him previously. All of this information has been put in front of this jury previously. There's no relevance to Mr. Sprinkle at this point saying, again, regurgitating all of those and saying why they were important to him or important to the investigation. What importance they have, ultimately, they can argue in closing, but the jury's this is already before the jury. And so if I did not say that this evidence would be cumulative, I'll add that as well. But for the most part, it is irrelevant, and his course of conduct and why he found it to be important is not relevant to this jury.
Yo, stop what you're doing real quick. Hit that like button and subscribe to the channel. It's free. Hit the like button. Share the video. Hit the like button. Let's dig.
Yes.
Would you put it up?
First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments. Where's the phone number? There it is.
Yeah,
Okay,
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him what handle it's next to, and Your Honor, what he did after seeing what he saw on this social media
That's not what you
page.
asked, though. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper, and so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because this is legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information.
See, you definitely got to salute to the YSL team. Now, they are definitely paying attention, because what the prosecutor and the state keeps doing is actually playing on verbiage and wording. If they can say one thing but make it mean another thing, but have it represented as another, if you were the jury, which one would you believe? Now, it's interesting that they keep catching all of this wordplay, and I salute to them, because as I keep telling everybody in each one of my videos, the state's key that they winning over on these people, if they keep taking advantage of those in the system, taking advantage of those on this case, is that they're playing with words. If you can't read and you're not understanding what they're actually saying, it'll go over your head. But luckily, YSL team is definitely all sharp, standing on point, and definitely paying attention. Let's dig.
Remember the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being...
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked
I
that.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous, because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. Here. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I mean, I can't figure out what it is. if it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
Now, in my opinion, I feel like the state is definitely doing all of this purposeful. Is it intentional? Absolutely. Why? Because at this point, we've all seen that the state is willing to do anything they can just for a conviction. So ask yourself, is the prosecution's behavior actually unethical, or are these just honest mistakes? And how many times will the judge actually let the state keep presenting evidence in front of the jury that keeps getting misrepresented in the same way? Is the state actually misrepresenting information just to sway the jury in their favor, or will the prosecutor's honest mistakes fall in the defense's favor? We watched the state misrepresent information when it came to the music and the label. We watched the prosecutor misrepresent information for a warrant just to go get a witness, and not to mention the misrepresentation of Mr. Sledge's plea on that 35-year sentence. Is the state at this point actually just playing for keeps? And is it not clear that at this point of the trial, the state's willing to try anything just to get a conviction? Let's be real. When's the last time you saw a plea on probation end up being equal to a life sentence? When's the last time that you saw a case so solid where you got to keep adding witness? When's the last time that you saw the prosecutor actually turn bully to victim and not to fail to remember the track record that they actually have with their own star witness? Is the state that desperate that they're willing to sacrifice the integrity of this trial just for a conviction? Or has this trial actually been compromised since the beginning? Man, y'all make sure y'all jump in the comments, let me know y'all's thoughts. Subscribe to the channel if you're not subscribed, and definitely tap that notification bell. Was it a good feeling to see the judge actually put the prosecutor in her place? And how many times will the judge continue to let misrepresentation of evidence and facts come in from the state? Man, it's your boy Jay. Until next time, y'all remember the life you save might be your very own. Until next time, gone.